Well, friends, from international, we come back to our own station, input tax credit. Most of us know this issue so very well.
And still we don't know.
Still we don't know. There are two basic issues as professionals you must learn, whatever is our age. One is reading. Reading is the core activity of a professional, which most of us don't do. Acquiring knowledge, that is 20% of what we have done. Empowering yourself with knowledge, another 20%. 60% is applied knowledge. Applied knowledge gives you power, not knowledge. Tax and wise, ITC, 3B, 2.1, all bakwas, this is all you are acquiring knowledge. How do you interplay this with the law in practice? That is called applied knowledge. One of the greatest philosophers, Leo Tolstoy, who always said you learn more by listening than reading. Einstein, they always said, if you learn to apply knowledge, for example, हमारे यहाँ सास बहू के झगड़े होते हैं, सबको पता है सास माँ की तरह, सास को पता है बेटी मेरी बहू बेटी की तरह है, नॉलेज तो है, रामायण भी पढ़ी है, महाभारत भी पढ़ी है, but we don't apply it. So is case with old parents. Yes. For example, Mr. S.C. Bharti, Rajesh Khurana sir, K.P. Singh, me, Pramod Gandhi, हमारी बच्चों से क्या requirement है? These buggers need me, we don't need them for anything. But they don't apply knowledge. So is the case with this input tax credit. Most of the litigation, I can tell you with guarantee, because the people who filed returns, people who gave opinions, they were awfully wrong. They had a shorter view of this longer proposition. Just to make some money, we give wrong opinions. Like somebody just now in Primal Steels went to Supreme Court. He's a friend of mine in Rajasthan. But that was such a stupid act to do. You ruined everything. Because you didn't want to deposit 10%, you challenged 16.2 when your appeals were not valid. You didn't deposit. How do you expect Supreme Court will interfere in this? So that was, again, that is where the knowledge was half-baked. Like if I start going to Supreme Court, I don't want to practice in Supreme Court. I don't know how it worked in Supreme Court. We don't know. I will never go. But as a lawyer, you can tell this was the most stupid act done by that lawyer. He ruined the entire profession on 16.2C. So what we are going to study today is not going to be routine. It's going to be much on a different dimension. How do you start litigation once you are assessed? Now, these are the sections you must read. These 4 sections have to be interplayed. Because the cause of action arises in all these 4 sections. Section 16. Section 16.1 is the only substantial provision in section 16. All other remaining 4 subsections or whatever their numbers are, they are, in my view, formal provisions or, as European call, machinery provisions. कम मिलेगा, कितना मिलेगा, कितना रिवर्स होगा. They are not giving you input tax credit. They say कि तेरे को 16(1) में मिलता है. It's subject to all this. So what does 16.1 say? This is where you have to apply your knowledge when you go into litigation in input tax credit mechanism. If a registered person buys goods or services or both. Now if you see European law, it deals with only goods or services. It doesn't deal with both. You go to Gulf VAT, it doesn't deal with both. It's goods or services. Only in our kind of GST mechanism, we have goods or services or both because of stupidity of this government, because they cannot classify how to follow these statutes and principles. Goods or services or both intended to be used in the course or furtherance of business. So how many definitions? Registered person. Section 25. आपको पढ़ना है? कौन होता है registered person? 25. Right? That is, you get a GST number. Now they are not using the word registered taxable person. They are using word registered person. In law, there are distinctions, but common parlance is the same thing. Goods or services or both. Supposing I issued you a tax invoice for sale of land. Who stops me? Nobody can stop me. Will you get ITC? You might say, I have a tax invoice. इस पर tax charge है, मैंने payment किया है. But these are not goods. If you see definition of goods, it excludes capital goods. So you have to go to section 18 to claim ITC in capital goods. Goods में नहीं. Intended to be used or used in the course of business. In the course of is a belagam ka ghoda phrase. Mostly it's a phrase used in Companies Act for the companies, but there also this phrase is not defined. So if you buy some goods, which as an officer I think, no, they cannot be used for your business. Ownership shifts upon you to prove that these goods were to be used in the course or furtherance of your business, or they were intended to be used. Then you shall be entitled to input tax credit that will be transferred to you your electronic credit ledger. That is 16(1) does not give you any input tax credit. It only gives you an entitlement. That's why it says subject to section 49 or subject to rules that may be prescribed. In section 16(1), there are 10 words which are defined in section 2. For example, the word prescribed, such a common word, is defined. It's prescribed in the rules. So if they issue a circular, can you say this prescribed? Circular in section 168. So when you read these kind of provisions, you know the law. पता आपको registered होना है, tax and बकवास होना है. But once you read this law, now you are applying your knowledge. So when you are drafting an appeal, you have to spend time कि उसके 50 invoice controversy में है. As a good professional, you are supposed to see all 50 invoices. Don't go by 3B bakwas. Returns have no value in litigation. Returns have no value in litigation except for quantification of figures. We have one of the appeals coming up today. The taxpayer bought Ferraris. उसका input tax credit claim कर लिया. Now there is no assumption he or she cannot claim input tax credit. But what you have to prove? It was intended, pla pla pla. Then business is defined, person is defined, service is defined, goods are defined, taxable person is defined, electronic credit ledger is defined, section 49 deals with utilization, and then say subject to certain restrictions as may be prescribed. This is 80% of input tax credit litigation in section 16(1). Everything else you read in the act, that is not a substantial law which cannot be challenged. They are machinery provisions. 100 में से 2 रुपए देंगे, 4 रुपए देंगे, 5 रुपए देंगे, 6 रुपए देंगे, नहीं देंगे, जो भी करेंगे. Now when you come to section 16(2), you have to be right here, absolutely here, hear me properly if you want to understand this litigation. 16(2) deals with a non-obstante clause called notwithstanding anything contained in this section, not in this act. So 16(2), if at all this is an overriding provision, I have my doubts. Now notwithstanding does not overrule 16(1). It says notwithstanding anything contained in this section, you have to fulfill the following conditions to be eligible to claim input tax credit in 16(1). There are 7 conditions. Now what government did, they have restricted your input tax credit to 2B, क्या बोलते हैं उसे? 2B, उससे ज़्यादा आप ITC नहीं ले सकते. हमारे सारे स्टालवर्ड जो वकील हैं, क्योंकि इनमें उनको समझ नहीं आया, इसलिए किसी ने रेट नहीं डाली. How can, who the hell is government to decide this? Why? There are reasons. Because input tax credit is not your vested right per se. It's a concession given by the state. And concession can be conditioned to whatever they think right. Like right of appeal. It is subject to conditions. This concession becomes a vested right after you satisfied 16(1) and 16(2). To make this input tax credit a vested right, the onus is shifted upon you under section 155. So you want to claim ITC, prove it. Notwithstanding whatever the provision is, the provision exists in law, unless it's quashed. And the language used in 155 is very imperative. The recipient will have to prove he is entitled to input tax credit. 16(2), most of the conditions you will be able to satisfy it. There are 3 conditions which are extremely important. First one, you should have filed a return under section 39. There are 2 definitions of return in section 2. One is a return, one is a valid return. Valid return is mentioned in section 39 only. Definition itself says valid return means a return as prescribed in section 39. Section 39, no return has been prescribed till today. 3B is now deemed return. It was never a return earlier, now this is a deeming return. That means if as an officer, I want to deny input tax credit to you, I will say your return is not valid. Supposing it is not signed, supposing you have not paid tax as per returns, you can file the returns without payment of tax, there is no bar. हाँ जी, हमने किए हैं सर मध्य प्रदेश में रिसेंट बिना टैक्स के पेमेंट किए, रिटर्न फाइल किए. अगर अभी कुछ बैन हो, मैं 4 महीने पहले की बात कर रहा हूँ. अब वी आर ओनली ऑन विदाउट सेक्शन 80 ऑर्डर, वी आर डिपॉजिटिंग मनी. This was such big case. So an officer goes through return, he calls you not under a show cause notice, just by a letter कि ये दिखाओ, आप इंफॉर्मेशन दो आप. He finds कि तुम्हारे सारे क्लेम गलत है. That is, your return was not valid. I will keep this point pending as an officer. I'll say now you come up. Supplier must have paid tax. I'm not going to dispute how it is my duty and what is the mechanism available. Some high courts have said. So that high court in writ, they can say whatever they want to say. Supreme Court has to say on this issue. Why so? Because GST mechanism presupposes that this is a revenue neutral proposition. 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 This is a revenue मैंने परचेज किया, मैंने 100 रुपये टैक्स दिया सप्लायर को, मैंने सप्लायर को जमा नहीं कराया, रिवर्स चार्ज भी नहीं जमा कराया। सप्लायर ने वो भाग गया, वो हो गया वो इंट्रा कम्युनिटी मिसिंग ट्रेडर, उसने रिटर्न फाइल नहीं की, या उसने कैश टैक्स पेमेंट नहीं की, या उसने अपना गलत इनपुट टैक्स क्रेडिट उसको एडजस्ट कर दिया। नाउ द ऑफिसर देयर थिंक्स वी डिडंट गेट टैक्स। नाउ सेक्शन 53 सेज whatever your taxes you have collected for a destination in Delhi, you transfer the tax to Delhi. अब महाराष्ट्र will say, why should I transfer the tax? मेरे को टैक्स मिला ही नहीं, I didn't get tax, why should I transfer to you? So unlike European Union where local tax authorities have a mechanism to automatically transfer the taxes subject to disputes, हमारे यहाँ ऐसा है नहीं। इंटरस्टेट काउंसिल में बहुत बारी बकवास करते हैं सारे मिनिस्टर हमारे, लेकिन वहां कुछ होता नहीं। तो नाउ दे से कि नो योर सप्लायर वाज बोगस, नॉन एग्जिस्टेंस, फिक्टिशियस, सर्कुलर ट्रेडर, चोर, भाग गया, आपका कोलूजन था, तो 6-7 रीजन दे गिव यू। द अदर कंडीशन इज कि यू हैव ए टैक्स इनवॉइस। If you go through VAT, there the particulars of tax invoice was mentioned in rules. Here the Act mentions the provision section 31. So if you have not mentioned full HSN code, your tax invoice is invalid. How will an officer know what have you done? So it picks up your 2-3 points. He says you have, notwithstanding anything contained in this section, that including section 16(1), आपने इसकी कंडीशन सेटिस्फाई नहीं किया, I propose to deny your ITC. और he says कि आपने you have failed to pay to the supplier full payment including tax within 180 days. That's one more issue coming up. Then comes 16(4). You have 16(2), a negative clause. There the word used is notwithstanding. 16(4) doesn't use the word notwithstanding. He says no credit, but this too a negative clause. So in one section, you have 3 provisions that require a serious interpretation. मैं 16(1) को सेटिस्फाई करता हूं, मैं 16(2) में फंस गया। मैं 16(2) को सेटिस्फाई करता हूं, वो कहता है नवंबर के बाद है, मैं आपको आईटीसी नहीं दूंगा। सो विद इन दिस 4 सबसेक्शंस वी नीड टू अंडरस्टैंड व्हाट इज दिस इंटरप्ले ऑफ दिस वेरियस 16(1) विद अदर सबसेक्शंस। तो वंस वी रियलाइज एंड अंडरस्टैंड कि सेक्शन 16 गिव्स यू ओनली एंटाइटलमेंट टू क्लेम इनपुट टैक्स क्रेडिट, you are very clear that all these subsections are constitutionally valid. If we presuppose, as held by Supreme Court and ALD Automobile is the latest case, many cases of course, that ITC is a concession given. So once 16(1) gave you a concession in the form of entitlement to claim input tax credit, this concession is now governed by 16(2), 3, 4, 5. Now if you sit down with this knowledge, apply your brain, how do we come out of this mess? This is where you require a litigation strategy. We will discuss. Read with section 17. 17 also has 3-4 subsections with notwithstanding. It says notwithstanding anything contained in section 16(1), not entire section 16. So what is 16(1)? You purchase the goods or services both intended to be used in the course of furtherance of business. ये आपने प्रूफ कर दिया, मैंने बिल्डिंग बनाई, बिजनेस के लिए बनाई. So that's why they say कि notwithstanding So what is the meaning of non-obstante clause? Wherever the word notwithstanding is used, it creates exception to the main provision. Main provision will not prevail. I won't say it will override. Notwithstanding always doesn't override in law. But in the context of this particular scheme of taxation, it overrides section 16(1). आपने बिल्डिंग बनाई, कार ली, आपने क्लब खोला कि जी मेरे तो कस्टमर आते हैं इसमें, कहते हैं बैंड है सर. So once you come in 17, it's again not a substantial provision. It only regulates the quantum of ITC which you would have been entitled under 16(1). कितना देंगे ये नहीं देंगे. तेरा 100 रुपये है, 40 रुपये बिल्डिंग के नहीं देंगे, 10 रुपये की तूने कार ली थी मैं नहीं दूंगा, 50 रुपये ले ले. तो entire scheme of 17(1) regulates your entitlement of input tax credit under section 16(1). What is the main thing in section 17? There are two subsections have explanation regarding value of supply. One says, I will use the common word, not the schedule entry. High seas sales shall not be included in the exempt sales. So what is high sea sale? Can anybody tell me what is high sea sale? Anybody? Explain the concept. चल छोड़ना यार. इसको आगे एक्सप्लेन करो, ये तो ठीक है. ये सेक्शन 5 में डेफिनेशन थी सेंट्रल सेल टैक्स एक्ट में. The correct interpretation which we will be saying is, before goods are assessed based on your bill of entry, only after assessment goods can cross custom frontier. You are right, but you know further steps ke what is custom frontier? Custom frontier is within Indian territory. It is deemed high seas. वो अलग चीज है, इसको कॉम्प्लीमेंट नहीं कर अभी. ईपीसी जैसे कुछ नहीं है यहाँ पर भी, वो डोमेस्टिक होती है. So when we say high sea sale, you don't pay tax. Who pays tax? The person who files bill of entry, not who will clear. Clear तो CHA भी कर सकता है. As lawyer, you have to use the phrases which are used in law. No common man, we are lawyers. Any person who files bill of entry will pay tax. That is, high sea sale can be multiple, 1, 2, 3, 4, 5, 6, 8, 10. If you go to Bombay, this is how oil is traded. Soybean is traded in Chennai. एक bill of lading 10 जगह is sold on high seas, adding money. So the final person pays. जिसने bill of entry फाइल किया, उस टाइम का वो टैक्स देगा, उस डॉलर के रेट पे टैक्स देगा और सारे खर्चे उसमें ऐड होंगे. Right? So it says high sea sale, the supplier has not paid tax. Tax is paid by person who is clearing the goods, because the import goods are under kind of a reverse charge. I won't say kind of reverse charge. So if it is exempt, so 17(2) should not give you input tax credit. So they have added explanation कि इसका valuation exempt sale में नहीं लेंगे. Now section 17 uses 6-7 words which are relevant for us to appreciate before we go into litigation. It differentiates between business purposes, non-business purposes. That is 17(1). आप पेन डीलर हो, आपने पेन ट्रेड के लिया, आपने 500 लीटर अपने दुकान के लिए, अपने घर के लिए, बिल्डिंग के लिए पेंट करने निकाल लिया. यूरोपियन वेट कॉल दिस इज डीम्ड सप्लाई. Here we say this is personal use. So 16(1) gives you input tax credit subject to section 17. The crux of 17(1) is if you make complete taxable supplies, that is, you use the goods for trading taxable supplies or to use in manufacturing, intended in the course of furtherance of business, then you get complete input tax credit. Otherwise, no. Then 17(2) says taxable exempt supplies. Definition है सेक्शन 2 में taxable की exempt supply की भी, वो आपको पढ़ना है. 3 similar lines. Then we come to 17(5). More so C and D. Biggest litigation is going to happen in this country in next 3 years on these 2 clauses. इससे बड़ा litigation GST में नहीं होगा, ITC से बड़ा litigation होगा ये. All builders are trapped. बहुत बड़े ट्रैप हैं, हजारों करोड़ की डिमांड है. Safari retreat was on this issue. A person filed a advance ruling Odisha High Court कि भाई ये मैं माल बना रहा हूं, मेरे किराए पे देनी है. He proved I am making it for rent. Why will I not get ITC? Rejected. Case went to Supreme Court. Supreme Court took years before they passed the judgment. All our senior lawyers, they quoted more than 13 Supreme Court rulings under Income Tax Act and under Excise Act. Okay, this is plant, this is not plant, whatever. Supreme Court rejected all these contentions. Now this is where your 16-month litigation also comes into play. You can't pick up a judgment and say, okay, I have won the case. Supreme Court said these judgments are not passed where GST mechanism is available. Income tax is not an indirect tax. ताजमहल होटल में टूटियां प्लांट थी, ये जीएसटी में नहीं है. अनंत थिएटर में सिनेमा हॉल प्लांट था, इसमें नहीं है. So they differentiated all judgments, rightly or wrongly, but that's a Supreme Court judgment. They rejected all this contention. But they came out with 3 propositions. In my view, for 16 months, forget 17(5) CD, it's a very relevant question. Functionality test. Say for example, Ferrari car. Supposing it were covered in exception, more than 13 persons, Ferrari bus hoti. The view could have been taken, I use it to carry my customers. I have evidence. Why should I charge? I can. There's no bar. Right? Or my foreign customers come, I give them on hire, bring evidence on record. Supposing you see this BSES, they create a civil platform and put transformers on them. Now does it become immovable property? Court says no. The platform is made just to make transformers usable. That was not intended to be, the property was not immovable. They were only putting a screw and belt and putting it on. So they introduced functionality test. Could the Safari Retreat company have earned rental income without this building? So they remanded the matter on this point. You consider whether this commercial mall can be held to be a plant. So what is our common parlance? Plant हम किसे बोलते हैं? कोई machinery है. But plant word is not defined. Define होता फिर तो कोई बात ही नहीं थी. Then Supreme Court also gave some hints. If you get output tax, why will you not give input tax? GST mechanism is based on this. And third, they say you have used 2 phrases in 17(5) C and D. In one you have used plant and machinery, and in what you have used plant or machinery. Now this is how law is read. I was telling you have to read law. कहते हैं जी और का मतलब क्या है? We are not convinced, Mr. Attorney General. इसका मतलब कुछ और है. Therefore you remand the matter. तो बहन मेरे को जज बनाते मैं तो सबको दे देता ना सर. On this issue also we will come, whether they should have discussed or not. भाई साहब उनको रिटायर भी होना है, क्यों बकवास कर रहे थे, समझ सुनाते मेरे से, हाँ रिटायर भी होना है भैया, ऐसे तो ना होता है कोई बात। भाटी साहब क्या कहने से ना होता है, भाटी साहब क्या कहने तो संजय शर्मा को काम नहीं करता, और जज कैसे करेंगे? Now what happened? They remanded the matter. We don't know who the case was remanded. असेसिंग अथॉरिटी को किया था, एडवांस पेमेंट अथॉरिटी की था, हाई कोर्ट को, किसी को उसमें क्लियर नहीं, केस इज रिमांडेड. When government was advised you are likely to lose 40,000 crore rupees on this issue. 40,000 crores was the ITC claim till this judgment in the country by builders. They retrospectively amended this plant or with plant and. So 17.5C and D both were equated so that Supreme Court judgment was nullified. And this was done retrospectively. Government has the power to retrospectively. Vodafone case, Mr. Panna Mukherjee amended 15 years back the amendment of particular word. But Supreme Court in recent Madras Bar Association, they gave a theory of when can you retrospectively amend the act. When there is an express judgment of Supreme Court, simply to nullify the Supreme Court ruling, you can't do retrospective amendment. There are many judgments now. That is why these cases are coming up on high courts, whether this retrospective amendment was valid. Now, insofar as safari principles were there, in my view, they were all gone after this was amended retrospectively. But do you think my ITC is gone? Supreme Court versus a one case of a commercial mall. There is no other case has gone to Supreme Court. So Safari Retreat did not deal with any issue, movability or immovability. Though the constitutional virus was challenged only on this ground, Supreme Court went on a tangent whether this is plant. The meaning was that even if property was immovable, if could be held to be a plant, you are covered within plant or machinery, entitled to input tax credit. And when they reconcile this explanation, definition of construction with this phrase, the conclusion was foregone. Yes, now it's a debatable case in favor of the SSC. But government was advised by Mr. N. Raman and Tushar Mehta that you are going to lose this. So they hurriedly, in my way, I will say stupidly, they amended definition. The amendment has been challenged. In my view, this amendment will be struck down.
But in a new case, if it is challenged in the Supreme Court, vis-a-vis that whether retrospectivity is valid or not, it can be...
No. See, Supreme Court issue still pending. If you are claiming output tax, why will you deny input tax credit? That issue is not settled anyway. So we are filing appeals only on this question of law. कभी यार टैक्स ले रहे हो, मेरा इनपुट कहाँ गया? मैं यू टेक इन डबल टैक्स, मेरे इनपुट भी खा गए, आउटपुट भी खा गए. नहीं कोई क्रैश नहीं, इसमें कोई क्रैश नहीं है, इसमें कोई क्रैश नहीं करता. Safari was not dealing with land or building. They were dealing with plant or machinery. No, plant or machinery. That's why they whether this mall is a building is a plant or not. वो इसमें land वगैरह कुछ नहीं था.
Otherwise भी तो GST आउटपुट अगर आप ले रहे हैं तो उसका इनपुट मिलना चाहिए.
हमें तो इनपुट देते नहीं, अपने यहाँ कुछ हमसे आउटपुट ही लेते हो हमारे से तो. Okay. So Safari was dealing with section 17.5 that even if you make an immovable property to be used by you in the course of your business, ITC is blocked. And then they further say, even if you construct for the purpose of your business, ITC is blocked. Personal building को मैं मानता हूँ कि I'm not using it for business, so no ITC. Supposing I make a building under mixed land use. 2 floors are commercial, 2 floors are residential. Why cannot I claim for 2 floors? Proportionate basis? It's allowed in section 17, provided property is not immovable. So Safari retrospective amendment nullified the entire judgment except and to the extent whether there can be an integration of output versus input. Then came judgment of Bharti Airtel, Delhi High Court. I've seen a lot of videos of our bar experts. Safari overruled in Bharti Airtel. ये किसी का heading था. तो I called him up. मैं कहा सर सेंसेशन कोई किसी का मर्डर वर्डर कर दो यार, ये तो मत बोलो यार. कहता सर वो उन्होंने बोला ना ये अलाउड है. मैं कहा भाई भारती में तो सफारी रेफर ही नहीं की गई, किसी ने एक पॉइंट भी नहीं लिया सफारी रिट्रीट का. बिकॉज भारती एयरटेल वॉज नॉट ऑन इमूवेबल प्रॉपर्टी. They were saying whether the property for which Bharti Airtel claim ITC, was it movable? They held this immovable. Now you get shocked. This word movable, immovable are not defined in GST law. There is no definition in section 2 in IGST or CGST. You go to section 3, Transfer of Property Act.
उसमें भी नहीं है सर.
उस example है.
Movable property does not include growing crops.
Example है. Right? Now, Supreme Court in Brick and Clean case, they referred this concept of movable property, immovable property. It's a very long judgment, a very beautiful. If you have the patience to read it, you should read if you want to know law. Bharti Airtel went on that tangent. Bharti Airtel law has demonstrated कि ये जो हम टावर लगाते हैं, हम इसका आईटीसी मिलना चाहिए. गवर्नमेंट ने बोला क्या मतलब तुम्हारे यार, नीचे तुम्हारे 4-4 फुट के तो वो सीमेंट का सारा अंदर जमीन के लेके गए हो, उसके ऊपर आपने लगाया, दिस इज इमूवेबल. दे डेमोन्स्ट्रेटेड कि ये नट स्क्रू है, हम खोल के कहीं भी ले जाकर जा सकते हैं इसको. दे फॉलोड, डिड दिस जजमेंट, दे हेल्ड दिस प्रॉपर्टी इज मूवेबल. Very few of you will know this was taken in SLP before Supreme Court. Supreme Court said in the context of this order we don't want to interfere, SLP dismissed. When SLP is dismissed at the threshold, Supreme Court does not lay down any law. Except and to the extent that this judgment in Delhi is binding.
Question of law is open.
No, they didn't write question of law is open. Then Supreme Court will write. When normally Supreme Court writes question of law is open. If you raise the question of law.
Because there is an explanation after 17.6 that telecom towers ITC is blocked.
This point was taken in Bharti Airtel. Okay, what about the explanation? They are excluded. They say we are not on this point at all. We are on movability or immovability. The explanation taken in Bharti Airtel. They say no, we are not in this point. Forget, don't tell us all this. You say this is immovable, we say not immovable. ये गवर्नमेंट तभी गई थी सुप्रीम कोर्ट के, हमने तो एक्सक्लूड कर रखा है. दैट इज द इनपुट टेस्ट क्रेडिट इंटरप्रिटेशन थ्रू वेरियस कोर्ट्स is going through innovation. Like in Calcutta High Court judgments, most of the judgments shock us. How can they pass this judgment? No other High Court has done. So on 17.5 C and D, all infrastructural issues are coming under a huge litigation. Except Delhi, क्योंकि दिल्ली जीएसटी में कुछ आता ही नहीं है इनको, कुछ नहीं आता है इनको. इनको सिर्फ रिफंड देने आते हैं, वो भी गलत देते हैं, रिफंड भी देने नहीं आते इनको. और जहां वो 74 का नोटिस पता नहीं कौन इनको बना के देता है, उसमें कुछ लिखा नहीं लिखा वो इशू कर देते हैं. लिटिगेशन हैपनिंग इज महाराष्ट्र साउथ, बहुत जबरदस्त लिटिगेशन है बिल्डर्स के खिलाफ. पुणे में मैक्सिमम डिमांड है बिल्डर्स के ऊपर ऑन सच इश्यूज. Now, once you say something is immovable, you say something ITC is blocked. What about repair and maintenance? They also go. Unless you get covered in one of the exceptions in section 17. Because the word construction defined includes renovation, maintenance, decoration, installation. And all for this, if ITC is blocked, everything else is blocked. Once you are doing something on immovable property. वो तो सारे 11 वर्ड हैं, सारा कुछ में कवर्ड है. हाँ, टू द एक्सटेंट कैपिटलाइज्ड, वो कैपिटलाइज होता है सर. मैं कहता हूं मैंने कैपिटलाइज नहीं किया सर, ऐसे जल्दी ऐसे मेरे को रेवेन्यू काउंसिल बनाओ ना, मैं देता हूं आपको. सी एक्सेप्शन इन मशीनरी प्रोविजन खुराना साहब, they are interpreted very differently than in the substantive provision. Like for example, if you say NALCO case of Bombay High Court, transitional input tax credit, section 140. They judge dealt with कि तुम्हारे ITC mechanism और section 40 mechanism दोनों अलग अलग हैं, interpretation अलग अलग है. So that means if somebody didn't capitalize, you will say कि मैंने 10 करोड़ बिल्डिंग में खर्च कर दिया, मैं उसका ITC ले लूंगा. आप तो यही कह रहे हो. I will never give you, no chance. So, movability, immovability. Now you come into various exceptions. जो 17(5)(e) से आगे हैं, उन हर सब क्लॉज में एक्सेप्शन है. ब्यूटी पार्लर, except when services are given to another beauty parlor. Cars, except when they are not used for renting or driving trainee schools. As each subsection you have to read. That is, if you have an issue where ITC is blocked on certain issues which are blocked, you have to read that provision. Are you covered by exception? Can you be covered by exception? Like Mr. Pran just now said, is capitalized. Well, this is an arguable point. We should take. In European law, I was reading a judgment, we were doing some research on some issue, for domestic issue. वहां भी ऐसा है, services in relation to immovable property. वहां जो टूरिज्म के फैसिलिटेटर्स हैं, वो होटल बुक करते हैं, करोड़ों रुपए के, दिल्ली के, करोड़ों डॉलर के. वो फ्रांस की एक कंपनी ने होटल बुक किया कि भी ये हमारे इस होटल से अरेंजमेंट है. उन्होंने बोला इनसे बात कर लो, आप जो दे डिडंट बुक जी होटल से भी अरेंजमेंट कर लो, ये रेट है, हमसे लो, हमारी कमीशन हमारे को दे दो. तो ITC was being denied. The European got said, is it in direct relation to immovable property services? Is he an architect? Is he a designer? Is he an interior decorator? The facilitator company, intermediary company, no tax. Section 17 uses the word in relation to in many clauses. You have to appreciate what is the meaning of in relation to. So how do we come out of it? Section 16(1), main section. Then satisfy the formal condition in 16(2). And ensure you are within 16(4). Now 16(4) deals with limitation. We have been brought up and taught by all our seniors, including Mr. Bhatia, that limitation is a matter of procedure. And we know the law, they cannot override my rights. But can we say 16(4) limitation is a matter of procedure? It gives you money. So if at all we have to say that 16(4) मैं क्यों नहीं ले सकता, I will fight it out. You have to come out on a similar issue litigated in any court, it was held to be a matter of procedure. Especially when it starts with a negative clause. That is, your right is taken away. Your right is extinguished if you do not claim up to 30th November or whatever is the date. Right? So 16(1) to 180 days. I see a lot of professionals fails to pay means I didn't have money, there should be intention not to pay. What nonsense, no. It's a very simple English, fails to pay for whatever ABC reason, ITC will not be given to you. In COVID cases, you didn't pay many suppliers who were dead. मर गए, आपने पेमेंट नहीं की उनको. Your ITC nobody will give you unless they bring an amnesty scheme that will be given to you. So fails to pay, notwithstanding even I sometimes talk fails to का मतलब ये है वो English का word है, dictionary का word है, no. It's a simple if you fail to pay full amount. Why so? Because the same law gives you कि जितनी पेमेंट आपने की उसका ITC ले लो आप. So there can be no interpretation. And 180 day is not subject to section 16(4). Whenever you pay. Let us say your case is in arbitration. You are infrastructure client, आपका arbitration में केस है, इसमें 15 करोड़ की पेमेंट आपने नहीं की, वो डिस्प्यूट में है. माल आपने यूज किया, मतलब डिफेक्टिव था. It's a recent case of Maruti. One of our suppliers, I am under arbitration with them. उसने पेंट सप्लाई किया, अंडरकोट पेंट किया, वो सारा पेंट उनकी प्रोडक्ट को खराब कर दिया, दाने वो पिन होल डल गए, पेंट खराब था. अब उन्होंने पेमेंट नहीं की, हम आर्बिट्रेशन में गए, उन्होंने वहां आईटीसी का क्लेम भी डाल दिया कि जी हमारा तो 15 करोड़ का, हमारा 28% आईटीसी नहीं है, वो भी क्लेम भी लो, इंटरेस्ट भी ले लो. Then I took a point, have you got a demand notice? Can you recover in anticipation? Still issue is pending. But this gives you a lesson. As a lawyer, as a professional, you should know this. What does this 180 day mean? 180 day simple mean from date of advice, we don't make payment, ITC has to be reversed. Now, ITC reversal, another big issue. There are 6 rules where ITC has to be reversed. Rule 37 onwards up to 53, whatever these rules are, am I right? इतना ही है ना? उन रूल के अलावा कोई ITC रिवर्सल का प्रोविजन नहीं है. उस रूल्स में 17, 1, 2, 3 सारे कवर्ड है. So if you get a notice on ITC reversal on any other ground, recently we did a case in Gujarat. It's an opinion, I don't do litigation anymore. गुजरात के एक टेक्सटाइल मिल ने एक स्पेशल, he imported a color from Japan. That color had to be kept in a particular lab which has some facility where the color will not decrease in quality. उसने वहां रख दिया. अहमदाबाद के बॉर्डर में कोई बॉम्बे सिटी है, वहां उसने खड़ा कर दिया. अफसर ने उसको नोटिस दे दिया, 5 साल का सारा आईटीसी रिवर्स करो. So somebody said that, no, it can't be done. Because ITC reversal, you are taking somebody's substantial right. Article 300 capital A Constitution, you are taking somebody's money. It is strictly governed by rules. When we filed a reply, I went to Ahmedabad. कहता वर्मा जी ये क्या है? मैं कहा जी आप इसको टैक्स लगा दो, आप टैक्स लगाओ, कहीं बताओ कौन से रूल में करोगे, बताओ तो सही सर, और कोई रूल है तो बता दो आप. इंस्ट्रक्शन है, मैं कहा वी डोंट बॉदर. हमारे पास एक सीबीएसई मेंबर की क्लैरिफिकेशन है. आई सेड क्लैरिफिकेशन, दैट्स नॉट बाइंडिंग अपॉन मी और यू, इट्स नॉट ए सर्कुलर, दैट्स नॉट ए नोटिफिकेशन. हाउ कैन दिस बी ए ऑफिसर्स ओपिनियन बाइंडिंग अपॉन यू? So therefore, when you deal with this ITC gamut, your knowledge is one part. आपको मालूम है ITC रिवर्सल के कुछ रूल होते हैं, आपको मालूम है कैपिटल गुड्स होते हैं, आपको मालूम है मशीनरी होती है, प्लांट होता है. But now you have to apply this knowledge when you are starting litigation. That is why drafting an appeal takes around 10 to 15 days. और आप लोग 2 घंटे में अपील बना देते हो. डाला चैट जीपीटी, बस हो गया अपील फटाफट. That was only for suits and application. नहीं इकोनॉमी यार, इस कंट्री में वो इकोनॉमी ऑलरेडी शट डाउन है, वो क्या कर लिया आपने? That article 142 of the Supreme Court was not dealing with such cases. तो आप इकोनॉमी तो ऑलरेडी खत्म कर दी, बाकी कुछ बचा ही नहीं इसमें अभी यार। ये हमारे तुम्हारे पैसे से बन रही है, जो तुम लोगों को रिश्वत देते हो उससे इकोनॉमी चलती है। कमाल करते हो यार, कौन सी इकोनॉमी चला रहे हो आप? नो, राजीव हैज ए वेरी वैलिड पॉइंट. If in COVID-19 they extended limitation for 3-4 years, why not for this? Because limitation where your rights are governed, for example, bail condition, there was a case after COVID-19. The State Department did not file a charge sheet within 180 days. On the ground का COVID-19 का case था. Supreme Court said, what nonsense? You can take somebody's right. स्ट्रिक्चर पास किए उन्होंने उनके खिलाफ. So when you apply these beneficial notifications, we have to be careful. They have to be strictly construed. Are you entitled to a benefit in that notification? See, there were two cases, Rajiv. One was Suncraft. Then came Dalip Kumar Sheth. In Suncraft, 3 judges, they said any debatable notification should be construed in favor of the taxpayer. Dalip Sheth, they overruled 5 judges. They said, no. Government is weak, not the taxpayer. If there's a debatable notification, rule in favor of revenue. So they up and down the entire notification. So you come on this litigation, 16(1), 2, 3, 4, section 17, movability, immovability, your ITC reversals. And finally, when you claim this is your vested right, how do we say this? Let us say RC cancellation. Section 29 has 2 main sections. One is 29(1) where you cancel on your own, 29(2) where the officers cancel suo motu. A, B, C, D छोड़ दो, E में आ जाओ. Now all these 5 subclasses carries violations which are matter of procedure or which are serious. So if they claim your registration was obtained by means of fraud, तुम्हारा सारा काम ही फ्रॉड से हुआ था, हम क्या बोलते हैं? सर हमारी क्या गलती है, आपने नंबर दिया था, you suffer, but rightly so, you gave them license to kill, why should we suffer? But then the entire GST mechanism, you have to find out, it is your money you are claiming. Prove you are entitled to claim it. So retrospective cancellation of certificate of registration and denial of ITC. No judgment helps you. Shanti Kiran was not under GST. State of Maharashtra, but this race trading was not under GST. Gevrimal was not under GST. The schemes were different. But continue to quote. They favor us. Not that we will not quote. But in my view, they have no relevance to GST mechanism. Because we are shifting to judgments now. I need not have it. Now when you read Ecom Gill Coffee Trading, what happened in the judgment? High Court also gave relief. भाई टैक्स बनवाया है, उसने पेमेंट दी है, उसका माल आया है, वो मैन्युफैक्चरर है, सब कुछ किया, और क्या चाहिए आपको? And they quoted Delhi High Court, Quest Marketing, done by Ruchir, na? Quest Marketing? नहीं, what is that पूछ रहा हूँ? Done by Ruchir, na? SLP in the case of Quest Marketing was dismissed by Supreme Court. Arise in other issue. Now, what did Supreme Court did? They say we'll examine this issue. They issued notice. So once they have to examine something on merits, based on SLP, they issue a notice and they stay the judgment generally. They said no, Quest Marketing is not a good law. Quest Marketing did not consider Section 155, say for example, or Section 70 of Karnataka VAT Act, which is paramateria to Section 155. This was not taken at all. And there is no proof on record that transactions were genuine. There is no proof on record beyond doubt that the goods were physically received by the recipient. Now this is where, as a lawyer, you have to learn to know English. Section 16 is crafted in past perfect tense. Has. Have, has. There is no is, am, was. That is, something should have happened before you claimed ITC. That's the meaning of past perfect. It's beyond past. अब गुड्स तो आपके पास है ही नहीं. Supposing you buy Toyota cars and you have a tax invoice which you have paid. Your cars have not come. Can you claim ITC? Why not? Tax तो दे दिया आपने भाई. Because there's a condition you should have received the goods or services. So when this Ecom Gill coffee trading case came, it raised three very serious legal propositions. Very serious for GST litigation. In my view, this is the Bible on GST law, Ecom Gill. It's been applied now more than 20 judgments in High Court where they have dismissed the cases. Allahabad High Court including. They said first, you have to see the substance of the transaction. If they prove there is no transaction, where is the question of ITC? They say your supplier was non-existent. उसकी कभी दुकान थी ही नहीं वहां. They bring evidence on record. हम क्या बोलते हैं? हमारे पास तो टैक्स इनवॉइस है. जब हमने माल खरीदा तो रजिस्टर्ड था. What is our fault? Well, this is a good point. But once they question the genesis of your transaction, Supreme Court said ITC can be denied. आप किसी माँ बाप का डीएनए टेस्ट कराते हो. कोई बोलता है जी मैं तो श्री वर्मा का बेटा हूं, सारी प्रॉपर्टी मेरे को दे दो. लेट मी टेक इट ऑन मी. क्या करेंगे आप? डीएनए कराएंगे? वो कहते नहीं साहब ये डीएनए को मलेशिया का है तो श्री वर्मा तो इंडिया में है. That is the basic genesis of a claim has been rebutted. So if you claim on this ground that the claim of revenue that the dealer was non-existent, non-functioning, you have to bring on record he is available. Now what we do in litigation? हम उसका एफिडेविट ले आते हैं. डीजीजीआई को डीलर नहीं मिला, वो कह रहे दुकान पे कोई है ही नहीं, दुकान खुली नहीं, हम उसका एफिडेविट लिए. That is a stupid advocacy. You should be charged, you should be arrested for filing a false affidavit. अगर somebody send affidavit, bring him now. Will it lie in your mouth कि we don't know him? आप बोलोगे जी मैंने तो उनमें उसके सीईओ को पकड़ा था, वो साइन करा के लाया था. Not supposing the proof कि वो उसके सिग्नेचर ही नहीं है. तो लिटिगेशन में हम लोग गलतियां करते हैं. आप ट्रांसपोर्टर के एफिडेविट ले आते हो 5 साल पुराने. भाई वो हमें तो कभी मिले नहीं, वो कैसे मिल गए? वो लिखते हैं जी ये ट्रांसपोर्टर नरेंद्र सिंह कभी को था ही नहीं, हमारे पास 2 विटनेस हैं. आप उसका एफिडेविट लेके आ गए. तो your litigation fails. So whenever you will want to litigate that these suppliers were existence, you have to say at the time when you dealt with, not now. So your ground of appeal has to be carefully crafted. You cannot use the language which shifts the onus onto revenue. The onus is still upon you to prove. You have to say at this time I did this KYC, I did talk to this person, this is his name, this is his phone number, etc. etc. अब जैसे नारायणा में होता है, स्क्रैप बेच दिया. किसको बेचा था? सर कोई ब्रोकर आया था, हमने उससे पैसे लिए और हमने बिल लिया, हमने माल खत्म. सबको पता है नंबर 2 किस पर चोरी है. तो why do they pay tax? Why don't they litigate? So on this issue के supplier was non-existent or the business was not there, you have to go to the relevant date and find out, can you bring some evidence on record to say that this allegation is not correct. Never as lawyers file any forged evidence. Client is not your God. You are your God. You have to take care of the person you see in the mirror in the morning. His self-esteem should not be demeaned to make some money. I am doing a case in Maharashtra for a government. It's a big company which was going for IPO. We caught him. He directed in jail for last 3 months. He filed false affidavit. We proved it's a false affidavit. जिसका एफिडेविट था उसका बंदा 2 साल पहले मर चुका है, उसका एफिडेविट फाइल करती है. Because government, if they want to inquire, they can inquire, they can spend crores. ये तो अपने स्टैच्यू पे 1000 करोड़ रुपए खर्च करते हैं, ये तो 25-30 लाख रुपए की बात है. There is no issue at all. So, as professionals, do not use any of forgery in litigation. Now, second issue is, he did not supply goods, he issued only invoices. Right? तुम कहते हैं हमारे पास तो गुड्स आए थे जी, हमारे तो स्टॉक लेजर है, हमने उस गुड्स को बिजनेस में यूज भी किया था, हमने उस पर टैक्स भी दिया है. These are subsequent events, as lawyers should know. The event is, when did you receive the goods? आपने यूज किया, उसको बेचा, टैक्स दिया. They are collateral evidences in support of your claim that this allegation is not correct. But that is not the right argument. You have to first prove these goods were received. That is why in Ecom Trading Guild, 6 times Supreme Court uses the phrase, you have to prove beyond a reasonable doubt that goods were physically received by you.
और वो illustration भी देता है. Way of telling the name of the supplier, name of the transport.
All this is, see this usage, हमने उसको माल बेचा, टैक्स दिया, मैन्युफैक्चरिंग में लगाया. These are events subsequent to receipt of goods. And that's natural, कहीं तो मैंने कुछ किया होगा. But if they prove कि आपके पास goods आए ही नहीं, now supposing there is an allegation in the adjudication order, कि they purchased the goods from ABC Limited, they have tax invoices worth 10 crores, and they have claimed ITC of 1.8 crores, 18%. We have made inquiries, this firm never existed there. We have spoken to landlord, he said we don't know anything about it. We have spoken to their neighbors, they say we don't know, we have not seen anybody, any company like this. So now what will you say? Sir, आपने उनको GST number दिया था. Now you cannot shift your onus back to the revenue. First prove revenue wrong, then onus shifted on the revenue. तो जो हम लोग केस बाजार में हारते हैं, वो इसलिए हारते हैं, हम शुरू में onus शिफ्ट कर देते हैं.
इसमें एक हो सकता है कि वो इंस्पेक्टर या रिपोर्ट या डीजी या रिपोर्ट लिखता है कि वो नहीं एग्जिस्ट करता. ओके, कॉल देम हु वेंट.
हाँ नहीं, I'm coming on this issue. So first, if there is an allegation against you in a litigation, first you have to bring evidence on record that this allegation is not correct. Then whatever positive, truthful, genuine evidence you have to bring that evidence on record. Don't fabricate. जिसे करते हैं ना, LR फैब्रिकेट कर ली, किसी ट्रांसपोर्ट बना दी, ट्रांसपोर्टर का रजिस्टर भी ले आए. There is a carriage by transportation act, section 8 का रजिस्टर प्रेस्क्राइब्ड है उसमें. जो आप रजिस्टर लगाते हो वो तो वो होता है ना, रूल वाला रजिस्टर उठा के ले आते हो. दैट नॉट रजिस्टर. सर हमने जीटी हमने 5% पुरस्कार दिया था, आपने कोई कंसाइनमेंट नोट बना दिया कोई आपने. नाउ सपोजिंग यू पेड आरसीएम एज ए सपोर्ट, आई कॉल द ट्रांसपोर्टर. डजंट एग्जिस्ट. Thereby simply by 5% on freight, you can take benefit of 2 crores. So these evidences are very weak evidences. They are documentary evidence. It can be created. Anything that can be created in Evidence Act is a weak evidence. Section 6, I always believe in Evidence Act, it deals with theory of res geste. Circumstantial evidence must be in your favor or in favor of revenue. So if revenue brings circumstances which are totally against you, first you have to come out of them, then shift the onus on revenue. And now you prove. वो कहते हैं इनके पास बिल नहीं है, आपने बिल दे दिए. इनके पास स्टॉक रिकॉर्ड नहीं, हमने स्टॉक रिकॉर्ड दे दिए. इन्होंने पेमेंट नहीं की, हमने पेमेंट की. इन्होंने ये माल इनके मतलब का ही नहीं था, हम प्रूफ कहते हैं नहीं, हमारे तो मैन्युफैक्चरिंग में यूज होता है. इनका इतना माल लग ही नहीं सकता. आजकल क्या है, इफ यू गो टू एआई, इट विल टेल यू कि इसको बनाने के लिए कितनी लकड़ी लगेगी. यू मेड दिस 100, लेट अस से वुड बॉच वी यूज इट 20 cubic feet. You have purchased 200 cubic feet. बाकी स्टॉक कहां है? दैट मीन्स द फेक बिल. तो आजकल एआई का जमाना है, ये बड़ा सिंपल सा काम है, इतना बड़ा काम नहीं। द थर्ड इश्यू इज देयर आरसीज वाज कैंसल्ड रिट्रोस्पेक्टिवली। ये सब मैं भाटी साहब के कहने से बोल रहा हूं, उन्होंने मुझे बोला था कि पूरा लेक्चर देना है, बोला था ना सर आपने, तो मेरे को शाबाशी दो कि इंस्ट्रक्शन मैं आपके फॉलो कर रहा हूं सर। हैं तो चले जाओ, कोई रोका तो ना आपको किसी ने। सर्टिफिकेट ऑफ रजिस्ट्रेशन, व्हाट इज द मीनिंग ऑफ सर्टिफिकेट ऑफ रजिस्ट्रेशन? इट हैज नो वैल्यू विद योर कैरेक्टर, it has no value of your conduct of business. It only entitles you to collect tax. इसका और कोई पर्पज नहीं। अब कितने सीए वकीलों ने अपनी प्रीमिसेस से नंबर लेके कितनी बोगस फर्में चलाई हैं, कितने लोग जेल में। आप कह सकते हो कि नंबर तो है जी हमारे पास, हमारा क्या हो गया था, तुम्हारा जी वकील सीए चोर था, सारा नंबर खुद ही ले लिया अपने आप उसने। So if certificate of registration is cancelled retrospectively, you have to first see on what ground was it cancelled. If it is 2092C, is one part, return file नहीं किया, ये की ना वो नहीं किया, these are not serious allegations, these are irregularities that are curable. 29E is not curable. There you have to get that order. आपके अपील में ऑर्डर लगा होना चाहिए कि किस बेसिस पर कैंसिल किया। जैसे दिल्ली वाले करते हैं, आपको नोटिस भेज नहीं किया तो आरसी कैंसिल रिट्रोस्पेक्टिवली, बात खत्म, घास काट दिया। हाँ अदर्स, हाँ। नाउ इट इज योर जॉब टू गेट दैट कॉपी, फाइल एन एप्लीकेशन immediately. They will not give you, make them pass the order. This order is appealable in section 1071. It says any person feeling aggrieved with any order or decision, this is an order, not a decision, is appealable. Get that copy. Then make your ground कि क्यों कैंसिल किया हमें पता ही नहीं. There is no allegation against my supplier. Others, क्या उसने अपील की है? ये भी एक कोलेटरल एविडेंस बनती है आपकी कि उसने अपील कर रखी है जी. हालांकि नॉट दैट इट रियली फेवर्स योर केस, बट दिस इज ए कोलेटरल आर्गुमेंट. बट गेट रेडी फॉर ए वेरी प्रोलॉन्ग लिटिगेशन. सुप्रीम कोर्ट इसमें आपको फेवरेबल जजमेंट देने वाला नहीं है. द लेटेस्ट ट्रेंड इज दिस, वॉट एवर दे आर डूइंग. सो व्हेन सर्टिफिकेट इज कैंसल्ड, it hits section 16(1). When you purchase, he was registered. When this cancelled retrospectively, he is deemed to be unregistered under 16(1). अब इसके तीन इफेक्ट होते हैं. ये you can pick up a principle in state of Maharashtra versus State Trading Company. He said the cancellation of a certificate of registration can affect the seller, not the buyer. ये प्रिंसिपल सेटल्ड है. वी कैन यूज दिस जजमेंट, पिक अप दिस पैराग्राफ एंड राइट कि जी मेरा. अब दूसरा क्या राइट है उसका? उसने जितने लोगों को सेल की आपने सबका आईटीसी उड़ा दिया. सपोजिंग उसने 5,000 करोड़ की ट्रांजैक्शन की है, मतलब सबका आईटीसी खत्म बिकॉज यू हैव कैंसल सर्टिफिकेट ऑफ रजिस्ट्रेशन. थर्ड, टू सपोर्ट दिस, always get account reconciliation against every transaction. On email, no letters. Letters today have no value. Email cannot be antedated. Make it a system in your client's company. हर बिल के बाद ईमेल भेजे, माल भेजे, आप बोलिए रिसीव हो गया या नहीं हुआ, जो भी आपने करना है, पेमेंट हुई, क्रेडिट नोट, डेबिट नोट, सब करो. Keep this evidence. But this is a very weak area of litigation. Now we come to last leg of this lecture, 16(2)(c). Supplier has not paid tax. This is 80% of litigation in ITC denials. There are many judgments, nothing from Supreme Court. Latest is, forget Sahil Enterprises, Instacraft, forget all these judgments. Single judge judgments is okay. Maruti Enterprises, this is latest, deadly against assessee. In this Gujarat High Court, DB, unanimously, all these judgments were quoted, especially Arise India. Arise India was under 92G of Delhi VAT Act. There the phrase was there that supplier should have paid tax to the government. This phrase was rejected by Supreme Court. They said this is not job of the buyer unless you prove collusion. Delhi VAT Act में और कोई स्कीम नहीं थी, यहां है. Therefore, Gujarat High Court rejected all the three judgments, Shanti Kiran, Srish Trading, and Arise India. They say these are not relevant for GST mechanism. They gave three key reasons in Maruti Enterprises. They emphasized the rules. That rules support main provisions. And rules are also sacrosanct in this particular matter, especially Rule 27 or something. Second, they say the judgments quoted, on the face of it, they favor. But when we go inside, the judgments are irrelevant. इनकी कोई relevance ही नहीं. The biggest issue in Maruti Enterprises that will trouble is Section 53. They introduced a new angle which no other High Court has ever done. हमने भी कभी Section 53 पहले कभी नहीं पढ़ा था, अब बड़ा ध्यान से पढ़ा है. Section 53 says the supplier's state shall transfer the tax charged on interstate billing to the transferee state. आज सप्लायर स्टेट कहता है जी मुझे तो 1 करोड़ 80 लाख टैक्स मिला ही नहीं है, मैं क्यों दूंगा? How will they transfer? Then they went on further to say that it is you have to prove you are entitled to ITC. How will you discharge this burden? Suppliers has paid the tax. They introduced one more new, very important concept. He said, when you read 16.4, I had deliberated this 3 months ago on this particular issue here only. Now they confirmed by Maruti Enterprises. They say 16.4 says that he can adjust his output tax against ITC by the eligible input tax. They say, can we say eligible is a superfluous word used by legislation? They say no. 92G never used this word. So the scheme of this is totally different from Arise India. They say eligible word means what? Now the question was, how do as a buyer approve his ITC were eligible or not? That eligibility condition revenue has to bring on record. कि जी ये ITC जो उसके सारे फेक बिल है, कोई सप्लायर है ही नहीं, जिसे माल खरीदा है वो दुकानें ही नहीं है. We have evidence on record. This part our chairman Mr. Khurana said, supposing you have this evidence, then under section 75 you have a right to summon them for cross-examination, which they will not do. Now this is where comes the European VAT concept. Now supposing a supplier 6-7 states में है, 4 बीजेपी रूल ने, 3 कांग्रेस में और राहुल कोकर कांग्रेसी के 3 स्टेट में जान पहचाने. कहते कौन सा नोटिस फाड़ के फेंक दो. ये खुराना साहब बीजेपी के भक्त हैं, कहते हैं हम ले आएंगे जी, फटाफट लो. That is, once you move an application, for each of such suppliers you have to move a separate application giving justification. The important ruling in this case is Kalra Glue Company versus Union of India. Kalra Glue Company, Union of India is the biggest judgment in tax matter. If you are relying upon information of a third party and trying to create assessment, then the assessee has the right to call him for examination. Now who will you call? Supposing you have claimed that supplies were done through brokers. The suppliers don't know you, they know the broker, call the broker. So as a lawyer you have to ask the client, how did you do this transaction? First tell me. Then you have to apply your knowledge, who is to be called? Broker, supplier, Now supposing supplier is dead, then what happens? His legal has no value. They can't tell you कि आपने माल बेचा था या नहीं बेचा था आपको. So Bharti Enterprises went on a tangent. When we come to section 74A, this is the key section.
मारुति एंटरप्राइजेज में जो लास्ट सेंटेंस लिखता है, गवर्नमेंट शुड डू समथिंग फॉर द लेजिटिमेट.
इसकी कोई बुक्कत नहीं है. उसमें मारुति में जो एक
मेरा कहने का मतलब है कि जज ये जो सारी अंग्रेजी,
अरे छोड़ो ना सर, वो गवर्नमेंट सर मैं पढ़ा सर, उसकी कोई बुक्कत नहीं है. हाँ,
सारी अंग्रेजी लिख रहा था, ही वाज राइटिंग विद इन द फ्रेमवर्क ऑफ व्हाट द लॉ इज रिटन. और लास्ट में जो एक सेंटेंस उसमें लिखा है दैट गिव्स अ ग्लिम्पसेस इनटू, इवन जज भी पेन में था कि कंप्लाई कैसे करेगा, ये रिसिपेंट कैसे कंप्लाई करेगा. दैट्स व्हाई दे हैव रिटन ओनली वेरी स्मॉल सेंटेंस.
मारुति में अब नाउ यू मेकिंग में ओपन अप, उसमें एक बहुत बड़ा पैराग्राफ है जो आपको फेवर करता है. लास्ट थर्ड पैरा में उन्होंने 2 लाइन लिखी है, क्योंकि मारुति वाज नॉट डिसाइडेड ऑन मैरिट्स, इट वाज डिसाइडेड फर्स्ट ऑन लीगल इशू. केस हैज बीन रिमांडेड, मैरिट्स पे भी आना है. उन्होंने बोला है कि यू स्टिल हैव रेवेन्यू हैज टू प्रूव कि वेदर देयर वाज अ कोलूजन. वो उन्होंने मारुति में लिखा है, बट वो 2 लाइन है, उस पर एलेबोरेशन नहीं है. हाँ नहीं सर, जजमेंट हम भी जब पढ़ते हैं बड़ा कुछ चूकते हैं. तो मेरा तो काम पढ़ना है, मैं तो कुछ करता ही नहीं ना जी, मेरा तो काम ही कोई नहीं. और so Bharti Enterprises hits you. Now when you go into litigation, you are hit with 74 और 74A. मैंने काफी शो का नोट्स देखे, उसमें आता है, ऑडिट रिपोर्ट में लिखता है वो कि तुम्हारे अंदर 74 की प्रोसीडिंग लाऊंगा. Whenever you are faced with an audit report, he is doing audit. He is an audit officer compiling your compliance reports. He is not an adjudication officer. Section 74 requires adjudication. This bugger has no powers to even write in the notice, I will initiate 74 proceedings to give you a threat. He is not acting as an adjudication officer. He is acting only as an audit officer. Section 65 उसका रोल है, उसमें क्या क्या करना है, कंप्लायंस किया, टैक्स दिया, नहीं दिया, जॉब रिपोर्ट बना के लिख ले. So if he threatens you, when you reply to the audit report, write 2 pages that you are biased, you have prejudged the issue. There is no inquiry in 74. मैंने फ्रॉड किया है, willful suppression है, क्या मैंने तो कुछ किया नहीं, आपने पहले मेरे को डरा दिया ऐसे. So these are also legal issue a litigant should know. All 74 notices you should very carefully read. He has to bring evidence on record to come in section 74. He can't say कि तुमने रिटर्न गलत फी पास किया तो 74 का केस बना दो. तुम्हारे शील वर्मा वकील है, हमारे को गालियां देता है, उसका 74 का नोटिस बना देंगे तेरा. No. You have to challenge the notification on the question of jurisdiction. Last is penalty 122. The law only says if penalty under 74 has been imposed, under 122 penalty cannot be imposed. 122 penalties do not require any show cause notice at all. They are not subject to any limitation. Wherever the lawmakers wanted to give a limitation, they gave in 73, 74, 74A. Penalty के normally किसी law में limitation नहीं होती, but few courts say should be imposed within reasonable period. But वो बड़ी पुरानी judgment है, latest में कुछ नहीं. There is also issue whether it's a civil penalty or not civil penalty. No. कि बाबा रामदेव बिल्कुल शरीफ आदमी. हाँ, जज कुछ भी कर सकते हैं, रीट पिटिशन है, क्या हो गया. Penalty was sustained. Supreme Court stayed. But if you do more research, it's clear that 122 is a civil penalty, it's not a criminal penalty. Therefore, section 74 ingredients need not be satisfied. It's not a penalty under 70. But if you put penalty in 74, for those reasons, then 122 also you will have to satisfy those reasons. Otherwise not. That is only 22(1)(a) subclause D. Baki 22 penalty they can impose any time. So when you now draft appeal on these issues, in all appeals you have to draft question of law. ज्वाइंट कमिश्नर के आगे भी क्वेश्चन लॉ आपको बनाना आना चाहिए आपको, बिकॉज ऑल दीज क्वेश्चन आर स्टिल ओपन. सुप्रीम कोर्ट ने कुछ नहीं बोला, हाई कोर्ट के जजमेंट कोई मानता नहीं, ये कलकत्ता हाई कोर्ट दिल्ली में नहीं मानेंगे. सो फ्रेम क्वेश्चन ऑफ लॉ इन ऑल योर अपील्स on the question of jurisdiction, on the question of applicability of the judgments, on the question of interpretation of section 16. Then write facts. Never conceal in facts. जो वकील फैक्ट्स कंसील करके करते हैं वो बहुत बड़ी मार खाते हैं, उनके केस हमेशा के लिए खत्म कर दिए जाते हैं. यू डिड नॉट अप्रोच द कोर्ट विद क्लीन हैंड्स. जो फैक्ट्स हैं आपके क्लाइंट के, आपने तो चोरी की हुई है, जिसने की साला भुगतेगा, हमारे क्या लेने देने. We will do whatever best we can do. Grounds of appeal, don't write 40 pages, nobody reads. GST लॉ में कोई भी अपील 7-8 पेज से बिना हो नहीं सकती. ऐसा इसमें कुछ हुआ नहीं है जो 7-8 पेज से ज्यादा लिख सको. एक भी जजमेंट फाइनल नहीं है, सारे केस रिमांड हुए हैं, कोई लॉ फाइनल नहीं किया गया. एंड स्पेशली इन सच बिग केसेस, फाइल ए वैलिड अपील. The latest judgment of C.K. Ramchandran last week by Supreme Court, it has laid down a drastic law. It says if you do not file a valid appeal, deficiencies cannot be rectified. After 4 months, your appeal right is extinguished. They say when you say deficiency means आपके साइन नहीं थे, आपको पेपर इनएलिजिबल थे. Now supposing your appeal was time barred, can the limitation be extended to revive your appeal? आपने 10 रुपये पैसे जमा नहीं कराए, 4 महीने निकल गए. Your appeal right, I'm not talking of High Court, your appeal right is extinguished. So you have to file a valid appeal. Means जो आप कर सकते हो, जैसे हम जीस्टैट में करते हैं, मैं लोगों को बोलता हूं या तो हिंदी फाइल कर देना, कोई बात नहीं, तो दिस इज ए इरेगुलरिटी विच कैन बी रेक्टिफाइड. नाउ सपोजिंग यू डोंट एनेक्स द ऑर्डर, फाइल द अपील, दिस नॉट ए वैलिड अपील. दिस इरेगुलरिटी कैन नॉट बी रेक्टिफाइड बाय ट्रिब्यूनल. इफ यू आर गोइंग आफ्टर लिमिटेशन, चैप्टर इज क्लोज्ड. इफ आई एम द गवर्नमेंट काउंसिल, आई विल नॉट अलाउ दिस अपील टू कैरी ऑन. इट हैज टू बी डिसमिस्ड because appeal does not know equity considerations. Limitation knows no equity. It works both ways. So file valid appeal, जो जितने रूल आप पढ़ सकते हो उसके हिसाब से ठीक अपील बनाएं, और जितनी एविडेंस आपको लगानी है बहुत ध्यान से सोच समझ कर. हाई कोर्ट कैन नॉट रीअप्रेज योर एविडेंस, ट्रिब्यूनल कैन विद योर एप्लीकेशन फॉर एडिशनल एविडेंस, हाई कोर्ट कैन नॉट. तो जब भी आप किसी बड़े केस में जाते हो, इफ यू डोंट नो, टेक ओपिनियन. ए लॉयर शुड हैव नो इंटेलेक्चुअल ईगो कि मुझे सब कुछ आता, नहीं आता हमें सब कुछ. हम भी लेते हैं ओपिनियन. मैं तो कई सीएस से लेता हूं जो मुझे कहा मेरे को अकाउंटिंग नहीं आती, हो सकता है मुझे उससे ज्यादा अकाउंटिंग आती हो, पर वो एक्सपर्ट है. सो डोंट बी, हम चैट जीपीटी देख लेंगे, वर्मा साहब से पूछ लेंगे, डॉक्टर साहब से पूछ लेंगे, हम अपील नहीं बना सकेंगे. अपील आपको पढ़ना है. ए क्लाइंट कम्स टू यू, ही पेज यू मनी for doing a good professional legal job. Don't be casual. Love you. Thank you.